Lord, third point is that
that matter.
that matter. My Lord.
Yes.
Now, my Lord, if your Lordship kindly come to the first impugned order.
First impugned order.
Lordship.
Yes, what is the issue, Mr. Banerjee?
Because, my
Please
Lord,
give
the
me-
point is that probate was granted
Probate was granted.
on contested hearing. Because
Who are you?
Lord, I am two sons of the testator.
Yes.
Therefore-
By virtue of will, one was deprived. We are deprived here.
By virtue of a will, Lord, it has been mentioned in the deed, will, that I have given vast of properties to my two daughters. That is why I deprived them.
You are the sons.
I am the sons.
Sons
That is
excluded.
why
Sons
No.
excluded.
sons were given.
Lesser properties.
No, the property, some of the property was given to sons,
Yes.
and some of the properties were given to daughters. Now, Lord, the property given to sons will provide by will. I'm telling you, Lordship, by will. But in the will, it has been mentioned specifically why I deprived my two daughters. That is by giving vast of the properties to them. Now, Lord, they contested. Now, Lord, on contested hearing, Lord, probate was granted. By this time, what happened? Executor died. Who filed an application?
Letter of administration. Converted to letter of
Then,
administration.
my Lord, it was converted to letter of administration for having a letter of administration certificate. Now, Lord, on contested hearing, letter of administration was granted. Now, Lord, based on that, Lord, I filed a civil suit. When I filed a civil suit in 2014, at that time, probate was granted.
Suit for
Declaration of title to the property excluding them. They are not entitled in accordance with the probate. But at that time, certificate was not granted. He died. Suit was pending. Lord, then 14 years, Lord, record was not available. Then it was, he died. Then, my Lord, the suit was filed in 2014. At that time, certificate was not granted. But my claim is on the basis of the probate of the will granted, title to the probate of the will granted. And their claim is that they are also entitled 1/4 share each, having that. So and so. Then, my Lord, we file an application, then contested hearing, that letter of administration was granted. Now, Lord, he filed an application after about 5 years. No, after about 10 years. File an application for revocation under 263. After about 12 years.
all right. So what
12
happened?
years.
What happened to that?
12 years. They filed an application under section 263. Number 263 ex parte, entire blood proceeding for revocation of the letter of administration is a state.
Was
a state.
Was stayed.
Yes. Then what will happen? Then they are forcing to hear out this suit. Now, Lord, there are two suits. One suit 2014 injunction against them not to transfer the property. By this time, daughters transferred the property, violating the injunction. Then second suit was filed. Now, Lord, second suit, they were blood added as a part. They were added.
What is the second suit for?
Possession and the deed is void because the injunction.
Violation of injunction.
Violation of the injunction, deed is void, and recovery of possession.
So
Second suit. Now,
second suit, recovery of possession from the transferees.
From the transferees.
Yes.
Now, Lord, that suit when he filed an application, we filed an application that this letter of administration is pending. Therefore, second suit be a state. Lord, they then jumped and said yes, it may be a state.
So it was a consent order.
Consent, practically not consent order, but court has passed an order on this. They did not hotly contest it. Passed an order, stay the proceeding till the disposal of letter of administration. Now, Lord, what happened? The first suit, that is 2014 suit, we prayed for similar stay because the letter of administration is a state, and my title based on probate, Lord will go. I cannot prove my title with regard to 16 annas on the basis of the probate of the will. Therefore, we said that let there be an stay accordingly.
Because the
Right,
very
second,
basis of your suit is that will.
on the probate of
On the probate.
yes. Well, then that is the question, my lord. Then after that, my lord, we file an application, Lord, under order 8 rule 9, that the letter of administration be granted. That is
Order 8 rule 9, why?
converted to a letter of administration.
No, order 8 rule 9 is leave to file additional written statement.
Lord,
You said you are the plaintiff.
that is misquotation of the section converted.
No, what is
Converted to letter of administration.
Yes, that was converted.
That was converted to a letter, my lord. We are ignoring that part. Lord, actual basis, that is why we are saying, but that can be treated as conversion application, whatever nomenclature might be in the application itself. Now, Lord, what happened? We said in our application, probate application, registered will. Now, Lord, according to section 51 of the Registration Act, will registered in
What is the impugned order?
impugned order is my application was rejected. On the ground,
What application?
my application for a stay of my suit, first suit, till the disposal of the probate. No, till the application under section 263. That application is rejected. Now, Lord, the point is, court has misunderstood the case because my application for probate is registered will. But, Lord, it is not a registered will, it is unregistered will. That is why we file an application for amendment.
Registered will or unregistered will, that does not make any impact.
Exactly so. Whether registered or unregistered does not make any impact.
Mr. Banerjee, will is not a compulsory registrable document.
Lordship, therefore, that is not an impact at all, whether notwithstanding registered or unregistered will. Lord, he said, trial court said, I paid for probate and letter of administration consequently on the basis of a registered will. That is in the pleading in the suit itself. Lord, subsequently, that pleading was amended. That it is an unregistered will.
Amendment allowed?
Allowed.
In this suit is not allowed. There is nothing.
So now, after allowing amendment, that is not under challenge. Amendment not under challenge.
Not yes. Page 34.
So if
Page 34 amendment allowed.
I will come to that. So amendment has not been challenged.
No.
Not challenged.
So now it's a letter of administration of an unregistered will.
Now, Lord, we said in our application, Lord, we shall be candidly tell your lordship the real facts. In the petition, my lord, for probate, we said registered will.
Yes.
Lord, in their objection was filed by saying that it should not be registered. No, it is a registered will. Their objection is registered will.
But you said registered will. You also said registered will.
I also said registered will.
Yes.
Inadvertently. Now, Lord, in the application, Lord, the objection filed, Lord, a stay application, Lord, objection was filed 151. There he said that it is a registered will. Now, Lord, it appears it is not a registered will. Will is single and unregistered will. Now, Lord, will whether registered or unregistered. Question is whether first question is whether I am claiming title on the basis of the identical will in which I got a probate.
But Mr. Banerjee, with the date is same or the
date is same. Date is same. And it is a wrong because, Lord, your lordship kindly look to Registration Act, section 51. There was no register. This is absolutely a mistake. That is why it has been corrected by amendment. Lordship kindly look to section 51 of the Registration Act.
Registration Act আছে?
Lord, may I?
Yes.
Lord, section 51, Lord, book 3. What book 3, my lord? Will must be in a book 3, not book 4.
Yes.
Absolutely inadvertent mistake.
No, no, how that is relevant here? You obtained an information.
No, it is relevant here that plaint is a apparent mistake. No, it can't be in a book 4.
All right.
Apparent mistake. Book 4.
Oh, they said registered in
There's a book 4.
four.
We have
No, they say their objection. If they object, immediately I can show that document. They said.
But the story is not the actual.
No. It is not a story. It is a fact. It is not a story. It is a fact which record shows that.
Now what happened? Let me go through the impugned order once.
Lordship.
In this suit,
I will come to you. Yes.
Yes,
What is the impugned order? Order number or the order
Number
dated 28th of July.
28th of July. কোথায় কত পেজ কত গো? আরে আমার এখানে তো পেজ নেই তোমার। এই দেখো না রাত থেকে এই করে কোথায় গো? Lord, third page. Lordship, kindly come to third page.
Please give me a minute.
First page. Fourth page, as per discussion. Apparently, the submission কোথায়? As apparently না আপনি কোন জায়গাটা করছেন 4 to 4 3 to 4 এইটা বলে এইটা এই জায়গাটা বলতে তুমি লেটার অফ অ্যাডমিনিস্ট্রেশনের পেজটা কোথায় দেখো কোন জায়গাটা বলেছে লেটার অফ অ্যাডমিনিস্ট্রেশন দেখো
Yes. Yes, Mr. Banerjee.
Number of certificate of letter of administration, Lordship sees that the findings were apparently the submission, page 4, my lord.
Yes.
Page 4 of
Page 4, yes.
page 4. So apparently the submission advanced by the plaintiff in support of their stay application and further states report under the states under unregistered will of late Sital Chandra Mondal and averments of the plaintiff are different. Lord, this is wrong because that is registered, my lord, has been deleted. Then as per plain, the plaintiff relies upon a registered will. No.
No, where is the plaint? You have said that it has been amended. Show me the
Yes,
amendment.
yes. Now, my lord, plaint, your lordship, look into the plaint. If
Because
your
the
lord,
sole basis of this judgment of the impugned order is that plaint proceeds on the basis of a registered will, and the application is on the basis of the unregistered.
Separate registered will, not this registered.
not separate, don't
The plain.
avoid, don't.
Plain.
Show me the plaint
Yes.
with regard to what is your statement.
Lord, this controversy will be at once, my lord, removed if your lordship looks into the certificate of letter of administration. Because that we have taken.
Mr. Banerjee, these are factual issues.
And yes,
The
factual
things
issue.
that you have also, Mr.
Kindly look
Banerjee,
to
you
the
have also
plaint.
not pointed out.
To the plaint.
You have also not pointed out this fact of amendment and other things before the learned trial judge.
This
You have
has
not
been
pointed out that it was amended, plaint was amended from
No, before the
registered.
trial judge, my lord, record is there that it was amended.
Mr. Banerjee, yes,
It was
maybe,
pointed out,
but no,
certainly pointed out.
no, not pointed out. Show me from this order. Nothing has been transpassed from this.
Very
You have
well, my lord. I'm showing your lordship first of all the plaint.
Or Mr. Banerjee, I can do one thing. I give you liberty to approach the learned trial judge with regard to that fact. Make an application, let the trial court consider.
ওটা amendment amendment allow করেছে
This
কোন
suit, no amendment application was
Order
filed.
এই rule
In
line
this suit,
amendment নয়।
paragraph 7,
এটা-
Yes, yes, that is why those facts are not,
will. And
Mr.
here,
Banerjee, those facts are not here.
No,
The
that
amendments-
my lord is clear. My lord, your lordship kindly come to that.
Mr. Banerjee, from
Order has been passed. Kindly look to
Yes.
the order, my lord. I am consciously, my lord, submitting before your lordship.
yes,
Kindly look to the order. Lord, page,
show me the plaint which
page
was,
34, lordship kindly. First of all, plain, my lord. Let us look to the plain first.
yes,
Lord, plain 93 of 2014.
it has not been annexed, man.
no.
Lord, that is why we have placed that before your lordship. Plain down. Lord, this is the plaint. Plaint.
No, plaint is not page 34.
No. Plaint has not been annexed
Shall I see this?
in the revisional application. Kindly look to the plaint, my lord. এই যে, 93 plaint.
93 plain.
হ্যাঁ,
Well, kindly see.
এই দাও
paragraph
আমাকে
7.
93 plaintটা দাও।
Yes,
You completely separate will, separate registration,
Yes.
other.
Kindly listen first of all, then answer.
yes,
Lordship, kindly come to paragraph 7 first. Registered will number so and so.
yes.
Property is given to two sons,
This was amended.
two
No, no,
daughters as
not only-
before execution of the
Mr. Banerjee, was this paragraph amended?
this paragraph. Lord, even if it is not amended হয়েছে,
Then,
order 829 was filed. Maybe, but my lord, identical.
Mr.
I
Banerjee,
can show before your lordship whether it is identical or not.
is the learned trial judge.
Kindly
The
look to
learned
next
trial
paragraph
judge.
8. Kindly look to paragraph 8. Lord, as a whole, it has to be read.
Yes,
Plaint shall be read as a whole. The
yes,
plaintiff state after demise of Sisal Chandra Mondal on 28/8/1965, predecessor in interest of the plaintiff, Nirmal Kumar Mondal, since deceased the eldest son, executor of the will, filed an application for grant of probate in favor of Nirmal Kumar Mondal and Sukumar Mondal. Accordingly, probate case number so and so was registered before the learned court of district judge Alipur in accordance with in respect of the entire state of Sital Chandra Mondal since deceased, and which probate became contentious, and subsequently it was numbered as so and so before the learned district judge Alipur, and same suit was subsequently transferred to the learned additional district judge Court Alipur, and aforesaid original suit number was renumbered as OS number so and so of the court of additional district judge. That the plaintiff state the defendant 1 to 13 are claiming to be the proprietor in respect of the Schedule B property described in schedule herein below situated within the jurisdiction of so and so.
Where is the probate application? Show me.
Yes, probate application, Lordship, kindly come to the probate application.
Yes.
Lord, probate application, it at page. Probate application page দাও। হ্যাঁ, আছে তো। Probate application. Yes. Lord, revocation case, my Lord, your Lordship.
Probate application. Please show me the probate application. What was your statement in the probate application?
আছে ভাই আছে।
Lord, please.
Yes, probate application page 63.
Page 63, my Lordship.
Lordship, kindly come to page 63.
Page 63, the same suit number, the separate will has been mentioned in the same petitioner here in paragraph number 6.
Petitioner is the only
Paragraph
legal
number-
heirs of the plaintiff state that
separate
the
will.
probate case became. No, it is not a
Completely
separate will, no.
Registered at Alipur.
Lord, his contention is incorrect because in his objection he said that. Objection he
His
admitted.
application.
Objection he has admitted.
Paragraph 6.
States that the probate case being so and so before the learned district judge so and so, that the petitioner legal heirs of so and so. Lord, here your Lordship sees paragraph 6, my Lord, in the probate case registered will. Lordship, kindly look to
Paragraph
6. One of grant of probate in respect of the estate of Sisal which executed a registered will before this so and so.
Yes.
Lord, they have filed objection registered will.
Yes.
But my Lord, it is not a registered will. It is your plaint. It is unregistered.
Mr. Banerjee, this is your plaint.
This is my plaint.
Yes. Plaint of the probate suit.
Maybe, my Lord, but
Yes.
if documents are unregistered,
Mr.
registered or unregistered immaterial,
Mr.
but
Banerjee,
it is granted.
yes. Revocation case, also revocation of registered will.
Yes, registered will.
Everything is registered.
All mistakes, my Lord.
But not
There-
only,
mistakes.
not only that, Your Lordship, kindly
How can I know from here? I can give you liberty. You can approach the learned trial judge by filing an appropriate application. Those facts cannot be gone into, Mr. Banerjee, in civil division application. These disputed questions cannot be gone into.
ভুল করেছো, মানে registered.
Divisional court cannot go into this because the only basis is that the court finds that in the plaint and other documents registered, in the application unregistered, apparently. So.
Lord,
Mr. Banerjee, apparently so. Apparently that is correct. The learned trial judge is correct. Now, if you want to show no, this was registered, other documents, then
There was no other document, only single document.
then you have to apply before the learned trial judge. Please make an appropriate application. I can give you that.
Then, my Lord, your
But,
Lordship, kindly give me
Divisional court
liberty.
cannot go into
No,
that.
give me liberty to file appropriate application before the trial judge and to reconsider the order.
No, file an application that will be considered.
Yes,
I
Lordship,
cannot
kindly
set
give
aside
grant.
from there. If you
No.
file an application that will be considered in accordance with law, subject to their filing any written objection to that.
Lordship, in accordance with law, with
Yes,
subject to
accordance with
filing law.
law.
But they have to be given an opportunity to.
One thing I am showing Your Lordship, what is happening.
Definitely,
I'm not going into the merits, do that there.
Completely separate will.
All right,
Bro, that will be clarified in the amendment.
please,
That will be clarified in the probate amendment.
this application under Article 227 of the Constitution.
Grateful to your lordship.
I,
What is your item? Why are scratching your head?
लिख देना
59.
I took instruction, my lord, what has happened on that day, 13th August, when the bailiff reached to the spot for suit premises to give possession. Bailiff was, my lord, kept lock and key. Then police came. Police.
What happened?
My lord,
151.
why I'm telling before lordship, my lord. The situation arose why. Police came. Police personnel asked the bailiff, what is your document? Show us that you are coming from the court. Then bailiff was rescued by the order of the court. Then on the next day, officer in charge was asked by the court to come and explain. He took apology. Then he expressed his opinion my lord, before the court that give me another chance. I shall take all endeavor. Then the learned advocate for the petitioner was the DHR was asked to file a petition for police's help. That has been kept.
That cannot be done.
My lord, that is, in
Sir, setting
fairness, my
aside-
lord, this has happened. And this order was passed on 25th August. And on last date, it was fixed on 21st July. On that day, my lord, it was
So,
resolution.
serve him a copy of the section 151
lord.
application. I'm directing
And
this.
yes, my lord, yes. Direct.
What is the next date fixed?
Next day,
Next date lordship is,
25th of September
yes.
for execution report.
25th of September.
This application under Article 227 of আচ্ছা ওইটা না করে না উইদাউট বিং সোয়েড ওটা কি কেটে দিন।
If the judgment debtor in a suit for eviction, well, immediately after passing of the decree, we prefer the appeal. And in connection with the appeal, an application for stay was filed. And the next date of hearing of the stay application was fixed on 19th September. Well, in the meantime, what happened? The decree holder put the decree into execution. Immediately upon coming to learn, they have already put the decree into execution. We took out a put-up application, moved the appellate
What is the decree for, Mr. Raut?
decree for eviction on the ground of digital. Well, I'm telling you, Lordship,
Occupation charges.
ready, to show my bona fide along with my stay application. I have filed application to pay addition. Your Lordship kindly annex.
What is the next date fixed?
Well, 19.
No, 25th of September.
Delivery of position on 23rd. Upon breaking of the padlock and my stay.
Mr. Raut, this order was passed in July 2025. Why are you challenging in the month of September?
August, 30th August.
No, the last.
30th August.
No. Order is passed on 18th of July.
Yes.
This is fixed 30th of August for verification and orders.
Yes.
Oh no, 30th of August.
Yes. Well, we moved the application before my put up application before the appellate court. We the appellate court said, no. Next date is 19, let it be fixed on 19. And in the meantime, took out the.
So 19th, what has been fixed?
Well, fixed, but in case on that, supposing it is found the
19th, where do you get that 19th?
19th, your Lordship kindly have it. But I'm coming to that. Your Lordship kindly paste at page.
19th is fixed in the executing court.
No, my lord. Appellate court. Your Lordship
No
kindly,
stay.
kindly page 27. Page 27.
The decree was passed when?
Decree was passed
19th.
15 May 2025. Immediately in the June, we have preferred the appeal. And immediately,
15th May 2025.
my lord,
What is the suit property?
suit property in respect of 2 rooms. Landlord,
Where?
suit property, I think, I'm telling. Yes. Govindo Mondal Road. It is Calcutta 12, Kasipur.
What should be the occupation charges, Mr. Raut?
My lord, I am ready to pay.
Why? I'm asking you, what would be the reasonable occupation charges?
Since Kasipur is a slum area, I'm telling you.
Mr. Raut, when you are for the
I don't-
tenant, it is a slum.
My lord,
And when you are for the decree holder, it's heart of the city of
My lord,
Calcutta.
my lord,
5 minutes metro station, 10 minutes railway station.
my lord, I do not know whether Lordship has got any knowledge.
I'm asking you, what should be the reasonable occupation charges?
2 rooms, your Lordship, kindly make it. Very. Make it 8,000. 8,000.
So do one thing, I'm not fixing anything. From May, the decree was passed.
May 25th May.
July, August, September, 4 months. So deposit for 50,000 in the executing court,
15.
50,50. 8 you said, 5 months is 40,000. It's your conservative estimate.
My
So
lord,
I'm making it 50,000
my lord,
deposit. It will be
my lord,
considered.
for the dispute with regard to fixation of ongoing charges, we have already applied because the court.
That is why I'm only directing you to deposit a consolidated amount. I'm not fixing anything.
My lord,
That will be adjusted.
What I know, before Puja told kindly put such a amount.
Yeah, Mr. Raut, the landlord is to get something.
No,
Poor landlord, 120 rupees rent.
my lord,
120 rupees rent was
my lord, I'll show your lordship. 5 properties are there. 5 property, 4 members.
maybe.
Degree will be certified.
That is another way. that is another way, but deposit that amount.
मला 20,000 kindly before puja.
20,000.
मला kindly. The application is pending. My application for fixation of occupation charges also pending.
This application under Article 220 by
Plaintiff.
My lord, I am appealing on behalf of the Bali Municipality
Lord,
led
here,
by
Lord,
Mr.
I
Rohan
have the
Banerjee.
petition and my advocate on record has done a mistake. During pendency of this other appeal, municipal appeal 218, Lord, the complainant has Lord, filed application under order 1 rule 10(2) and he added. Lord, I find from the order impugned their submission is also being recorded.
My lord, I also had a caveat.
But Lord, my junior Lord, while preparing Lord, the Lord, this revision
Has not added
application-
him.
No, Lord, he relied upon the short course title. Lord, it is not the decree. So, Lord, that's why Lord, the mistake, but that ought not to have been done. Lord gives me liberty so that I can Lord, add Lord, the private respondent over here. Not the private respondent, opposite party who has already been
Well,
added.
I was the
And I will.
petitioner at
He is present.
Yes. he
So
is
add
present.
him.
Yes, add. And Lord, I will also serve my learned friend a copy also.
Yes, what is the impugned order?
Impugned order, Lord, I placed on the last occasion, Lord. That,
Yes.
yes. Lord, your
Then
lordship
on
asked
the
Mr.
last
Banerjee.
occasion, I was not with you. I was not with you.
এটাতে খুব তাড়াতাড়ি yes বলছে not with you কোথায় no my lord I argued before your lordship that after my lord when this
That is
concept
why you paid for adjournment on that date, Mr.
no my lord, your lordship asked
He is saying
Mr.
yes.
Banerjee my lord she will say everything yes when it is my lord goes in his favor
Yes.
my lord no my lord your lordship asked my lord Mr. Banerjee since it's a Bali municipality matter your lordship asked Mr. Banerjee
that
to
was-
come
there
and
was a
thereafter
caveat.
yes Mr. Banerjee asked for some time since there are other proceeding pending he wants to take instruction Lord, copy
আমাকে
আমি
একটা কপি দিও
Section 11 CPC, res judicata. You
Lord,
are challenging the order date 30th of July.
Lord,
ঠিক ফাইল দিয়েছেন না অন্য ফাইল দিলেন?
কি দিল না না
Lord, it's 16th of July 2024. Lord, it's Rakesh Kumar Naik.
রাকেশ কুমার নায়ক না কি সব দেবরাজ দত্ত শ্যামলী দাস ফার্স্ট দিয়েছেন।
This is the
Yes,
the
yes.
writ petition. It was my writ petition pursuant to which the demolition order was
You are the complainant.
Yes.
complete.
Demolition order passed.
Passed.
He filed as appeal under 218(3).
My lord.
What order?
Filed
Appeal
appeal, the
disposed
demolition
of
was
or appeal
affirmed.
pending?
The demolition was affirmed. The demolition was affirmed
By the appellate court.
by the appellate.
By the Lord, yes,
By the appellate.
civil judge.
Now, my lord, we went to contempt as against the parent order pursuant to which this
Oh,
demolition was
so
passed.
I'm directing this matter to be.
Yes. Now I can Lord, say that
And-
yes, this was your lordship's
So I'm
last
directing this matter to be heard by the other bench.
Lord, these are the
My lord.
separate
Oh.
things.
Mr.
My-
Mukherjee, implementation and challenge has to be heard together
My lord.
by the same court
My-
in order to avoid
My lord, what
conflict of.
happens in that particular petition against that order, person to which the Justice Sinha again ordered demolition by vacating the parties there. My lord, they have
Go
one.
before that court, Mr. Mukherjee.
Lord, I cannot, my lord, the
My lord, has to.
kindly consider, my lord, here, my lord, I am, my lord, before your lordship under Article 227. Why, my lord, I say,
Only
my
there is
primary,
difference of only one article,
But it is-
226 and 227. Only difference is one.
but the problem remains, my lord, my submission is very
Yes,
restrictive.
what is your
My
challenge?
submission is very, yes, Lord, my challenge is not the order dated 16th July 2024, but my lord, I will place before your lordship, my lord, the entire conspectus of the matter does not deal with a situation. My lord, here is a case where there is no, my lord, extra flow, my lord, which is beyond sanction. Here it is that there is a deviation, my lord, whatever I have got sanction, I have made that flow up to that. But there is an internal deviation, my lord, of these rare spaces. That is the allegation admitted. Now, my lord, I say before your lordship, when this primary consideration was being made by the authority, at that juncture, the West Bengal municipal law was not amended. The Rule 32 was not been amended. Immediately thereafter, Rule 32 amended. And I applied for also regularization. I given your lordship on the last occasion an example that suppose, my lord, I have got also the regulation which your lordship on the last occasion, my lord, have apprised me that there is a regulation frame. So if after regulation, this, my lord, is considering, say for example, 30% beyond that, we are ready to consider as per the statutory provision to be minor. Mine may be 50. So up to 30 I am entitled to. Thereafter, rest portion will be demolished. Am I clear to my lord? So this consideration has not been done. My prayer for regularization is pending till today before the authority. This aspect have not been gone
My
into.
lord, I will just.
Your
point you-
regularization prayer was at what point of time?
Immediately after the provision of 32 came in. amended provision of 35 is placed.
After the order of demolition
Yes,
is passed.
yes, my lord. And my lord, I try to argue before your lordship, there is no cut-off date given.
Rule
It's like,
32, do you have the rule?
Yes, I
regional
have.
principal rules টা কোথায়?
my lord, rule 32,
Yes.
my lord, the proviso 1, this has been inserted by 27th of
Is it
July.
prospective or retrospective,
Lord,
Mr.?
No, my lord, I said, I will argue, my lord, kindly take up this book.
My lord,
All right, then-
my lord, let him add me as a party. I have a like to say as well.
Because he has to
I
be,
realize, definitely, my lord. That's why I opened my submission, my lord, saying that.
I'm keeping it after the vacation.
But kindly protect
lord.
me during vacation.
My lord,
Puja
my lord,
period,
my lord,
Lord,
my
I-
lord, this will come in. My lord, I will.
maybe, my lord,
My lord, Justice
this
Sinha has asked for a
My lord,
re-inspection.
Madam,
Why, my lord, at the instance of
the
no,
plurality.
division bench, I will also say.
my lord,
Division bench.
my lord, division.
Then Mr.
Why, but I will
One unauthorized.
Pending, it is
Once for all, it will be decided.
conspect us before the division.
My lord, I have gone to Supreme Court.
Kindly hear me, my lord. I am
Uh,
not a purchaser. My lord, we have gone before the division bench because at no
Mukherjee
point
guarded
of time, my lord, we were hard.
Mr. Mukherjee.
My lord, in this matter, Mr. Siddhartha Lahiri is appearing for the petitioner. He has not come to court due to fever. I'm just praying not today. He was
Aviators, my lord, kindly take up the matter on Monday.
he was there yesterday.
The interrogatories were directed to be furnished by them, nothing
As
more.
paid for by the learned advocate for the petitioner, list this matter in the. Yes, next.
Greatly obliged.
54.
Petitioner, your lordship.
You're for the petitioner.
It is for expeditious hearing of a suit, your lordship.
Expeditious hearing of what?
Ejectment suit, your lordship. That
What is the stage of the ejectment suit?
for framing of issues, your lordship.
This application on.
Expeditious disposal of the appeal, my lord.
Of what appeal?
The title appeal, my lord.
That
My lord,
appeal.
yes, my
Who
lord.
are you?
I am the respondent, my lord.
This
My lord,
application under Article 2.
My lord, my only prayer, my lord, Madam, 4127 is
Hard
fine.
along with that.
I'm ready.
Yes, that's the law. Yes,
So 56, my lord, I appear for the petitioner, my lord. My lord, the order passed by the DRT is under challenge. The DRT is not sitting. Not sitting.
for how long?
I don't know. It's still not sitting today. Tomorrow the resolution and the DM's order.
Resolution.
Tomorrow resolution. Till today is not sitting. He's not sat today. Tomorrow the resolution. Apart from put up, nothing will be taken up. And I do not know when the DRT will sit. Most importantly, my lord, the DM's order was under challenge in an IA, my lord. That has been dismissed by the, my lord, the impugned order. The impugned order is at, my lord, dated 1st of September 2025. My lord, admittedly, my lord,
What is the wrong in the impugned order?
I'll show you. Kindly seize the impugned order. Kindly seize, my lord, page 3 of the impugned order.
Page 3, yes.
Look, there were two borrowers. Look, kindly seize, my lord, the second paragraph. Start notices under section 13.2 and 13.4 of that were issued after the death of the co-borrower. Look, there were two borrowers, the wife and the husband. The husband dies before 13 notices have been issued, leaving the wife and the minor son. Minor son has not been made a party. The notice has not been issued on the minor son. That was the first issue I raised before the DRT. I said that since the minor son was not made addressed, the notice was under 13.2 was not addressed to the minor son, that was fallacious. Now, I'm going to kindly seize the learned presiding officer holds notice under 13.2 and 13.4 of the Act were issued after death of the co-borrower. Admitted. He admits it. Then the issue before the tribunal is the order passed by the learned CGM under section 14 of the Act.
The notice contains the name of the deceased person.
Yes. Kindly seize the notice, my lord. Kindly seize it at page. My lord, kindly seize it at page 46. Kindly seize Arnav Bose, co-borrower. Admittedly, my lord, Arnav Bose died on, my lord, Arnav Bose? My lord, 2011-2022. Seize, my lord. This fact is admitted by the presiding officer that the notice was served after the death of the co-borrower.
Where is the order of the DM?
My lord, DM's order is at page 88, my lord. Again against the dead person, page 88. Seize, my lord, Indra Kundu Bose and Arnav Bose. Now, my lord, kindly seize what the learned presiding officer holds.
Yes.
He says, my lord, the issue before the tribunal is the order passed by the learned CGM under section 14 of the Act.
Where are you reading?
My lord, page 3.
Yes, page 3.
My lord, this.
Yes, I've got that. Yes.
Now, my lord, most importantly, 13.2 notice sections 13.2 and 13.4 are notices are under challenge in the main surface application. Now, my lord knows section 14 is an extension of measure under 13.4, and my lord, everything stems from the 13.2. So, my lord, if the 13.2 is defective, my lord, 13.4 is defective, section 14 is, my lord, defective. My lord, measure under section 13.4 is an extension of a measure under 14 extension of measure on 13.4. Now, 13.4 presupposes that 13.2 is valid. Now, my lord, the learned presiding officer says issues of 13.2 and 13.4 shall be decided in the main surface application. I will not consider it right now. This is, my lord, the first error.
It prima facie appears to this court. It prima facie appears to this court
My lord, my lord, my lord,
None appears for the petitioner.
আমি তো বসে আছি আমরা করবো বলে। হলো না তো, না কি এটা হয়ে গেল ওরা।
Number 1848 of 2020 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Next.
My lord,
To the petitioner.
my lord,
Yes.
To 58.
my lord, I am wait, my lord, regarding item number 57, my lord.
Yes.
Item number 57, I am for the petitioner, my lord.
57 order has been passed. Now you have joined.
My lord, I am waiting for my turn.
Yes, I have directed the expeditious hearing of the suit as well as the application. So
My lord, regarding the application, it was taken on the last date, on 12th of November, September this month.
yes, I have
And
appeal pending, are directed to be disposed of expeditiously thereafter the suit.
kindly, my lord, kindly record my name, my lord. My lord,
ওই non appears টাকে কেটে দিন, কেটে দিয়ে ওনার নামটা। Yes, call the next matter.
grateful, my lord, grateful.
Thank you.
Lordship,
Yes.
58, I'm for the petitioner. Lordship, the petitioner is a plaintiff in the eviction suit.
What is the order under challenge?
Lordship, order 12, rule 6.
Order 12, rule 6.
The rejection of order 12, rule 6.
Order 12, rule 6 rejected.
Yes, your lordship.
What is the suit for?
Lordship, suit is for eviction, your lordship. Lordship, my order 12, rule 6 is on the ground that there was no specific denial of the allegation that the defendant has bought a property within 1 kilometer of the rented property. I have annexed the certified copies of the deed.
That ground, order 12, rule 6.
Lordship, there was
What happens to order 8, rule 5?
Lordship, order 12, rule 6 read with order 8, rule 5. There was no
Even if the facts are not denied, even then the court can require a party to prove that case.
Yes, your lordship, I'm ready to prove that case.
So why order 12, rule 6, madam?
Lordship,
Write it out on the suit.
Lordship may kindly come to the written statement once, your lordship.
Yes, yes.
Lordship, that is in page number 68, your lordship.
68.
Yes, your lordship.
Yes, show me the admission.
Yes, your lordship. Lordship, page number 68, paragraph 12 and paragraph 11.
Yes, paragraph 11
reference
and
to-
12.
Yes,
Yes,
your
where is
lordship.
the plaint? Paragraph 11, 8 and 9 and 10 and 11. Show me
Yes, your lordship. Paragraph
page.
Paragraph 8 is in page number 15, Your Lordship. I have given all the details of the registered sale deed, Your Lordship, with the volume number, with the date as well, Your Lordship. It was registered on 10th of August 2017. The property was purchased by the defendant along with his wife. My lord comes with a written statement.
Yes.
The two paragraph says with reference to paragraph 8 and 9, the plaintiff is put to strict proof thereof. It's a mirror paragraph in paragraph number 12 also. Lordship will take paragraph number 13 just for a reference. Paragraph number 13, the defendant states that with reference to some other paragraph of the plaint, it's denied. As well as the previous paragraph, that is paragraph number 10, also in some related to some other allegation, the defendant specifically denies. Only with respect to
Yes, yes.
the deeds, the registered deeds.
This is insane. Yes, you proceed. Yes.
Yes, my lord. Only with respect to the registered deeds which are annexed with the plaint, that the defendant did not deny it and has asked for proof. Lordship, what else proof other than the registered deed can the plaintiff produce?
This is a residential property.
Yes, your lordship, it's a residential property. Even the period of moratorium of 1 year has long expired. The property was bought in 2017.
This application under Article 227 of the Constitution of India
judgment, Your Lordship. May I be allowed to place two judgments, Your Lordship, on this?
Should have placed it beforehand. Yes, give it.
Lordship, both are of the Honorable Apex Court, Your Lordship. Lordship, the recent one that is of 2025 itself, Your Lordship.
Yes.
Lordship, the Honorable Judge has specifically,
Rajiv Ghosh.
yes, Your Lordship.
Yes, which paragraph?
Lordship, paragraph 31, Your Lordship.
Yes.
To make order or to pronounce judgment on admission is at the discretion of the court. First, the word may, Lordship. Lordship, paragraph 35, Your Lordship. Such admissions may be express, implied, that is constructive, may be in writing or oral, or may be before the institution of court, after the suit, or brought during the pendency of the proceedings. Lordship, Order 12, Rule 6 has to be read with Order 8.
All right.
Rule
Anything?
4 and 5.
Paragraph 31. What is the other judgment?
Yes, Your Lordship. Also of the Apex Court in 1993.
Yes.
Lordship, it was of almost of a similar nature, Your Lordship, wherein the defendant had said that the notice is not in accordance with law. The defendant did not deny the notice, but just said that it was not in accordance with law. That was presumed to be, that was taken to be admission, Your Lordship. Actually, the very first page, Your Lordship, the bottom 4 lines of the very first page.
Yes, Ashok. Uh,
The plaintiff petitioner is before your lordship, my lord, there is a
Yes, who is your caveator?
Biplab Adok,
Where is he?
Baru Association Room number 5.
You do not know him?
No, my lord.
Yes, yes, Mr. Ganguly.
My lord, the plaintiff petitioner before your lordship, my lord. My lord, kindly see, my lord, my suit is for declaration that the defendants have no right title interest over the scheduled plot number 818/1907. My lord,
You are
kindly
the
come,
plaintiff.
yes, kindly come to page 19 of the
19.
19.
Yes.
Kindly come to schedule at page 26.
Mr. Ganguly,
Hello.
what can be done?
My lord, Madurga is little bit
Look at the watch.
saying,
But caveator is there. That is what I am saying.
kindly then my lord, tomorrow
Tomorrow.
at the top one.
Because
Yes, yes, that I have seen.
that is why they were present. I could have
My lord,
taken up.
they will be trying to, my lord.
That is. Yes, show me what is the. You have
Yes,
filed a
my
suit.
lord, from 2017 till 2024, the learned court has pleased to grant permission. My lord,
You have filed a suit for declaration of
Yes.
title.
in plot number 818/1907. My lord,
81.
8/1907. Now I sought for 151 application, my lord, praying for police protection, my lord, so that I can the defendants cannot, my lord, disturb my puja, my lord, for conducting the puja, and my
Why it was rejected this year?
this year, my lord, kindly see the impugned order.
You must have violated in the earlier order.
No.
Then
Kindly come to, or it is not paginated. Kindly come to order dated 6/9/2025.
yes,
Come to the second paragraph.
yes.
Second page, my lord. My lord, kindly see third paragraph. The defendant number 1 further contended that the plaintiff petitioner observed Monosha Puja with the help of police authority in spite of the fact that the court order number 106 dated was pleased to reject the prayer of the application under section 151. The defendant number 1 further contended that one hand the plaintiff prayed for permission and police help for Durga Puja at possible property. On the other hand, prays for obstruction of the common passage which may obstruct the entrance of the possible property. Now, my lord, kindly see, my lord, the next two kindly skip next two paragraphs. At the auspice, it is admitted by both the parties to the lease that the instance suit is a suit for declaration and permanent injunction. It appears from order number such and such, this court was pleased to direct the plaintiff defendant number 1 to maintain status quo regards to nature, character, and position of the suit property as stood at on 13/6/2022 till disposal of the instance suit. It is also apparent from the report of the Sestadar, it has already been issued in titles. But there are two suits. One suit filed by me in 2013, and their suit for declaration in respect of a separate plot that was filed in 2023. Now, my lord, the learned court, kindly see, my lord, I was reading, it was also evident from the page of the record that the template did not bother to expedite the report. My lord, there was a surveyor first commissioner appointed, my lord, and the commissioner was pleased to, my lord, there was a delay in his part. Next, my lord, will find it is also pertinent to mention that celebration of upcoming Durga Puja, that is temporary making of puja pandal, deity installation, deity immersion, dismantle of pandal, etc. over the cost issue property cannot be termed as permanent change the nature, character, and position of issue property as is stood on 13/6/2022 to disposal of the instant suit in Stixen. Hence, the plaintiff petitioner may perform upcoming Durga Puja if does not contradict with the order of learned civil judge junior division second court Bardhaman. Now, my lord, the last, the third page, my lord, of the order. Under the circumstances, this court do not find justifiable ground to exercise the inherent power of the court cannot rely merely on the affidavit filed by the plaintiff and also allow the prayer of the plaintiff in absence of specific report of the survey first commissioner knowing advocate commissioner on the basis of mere apprehended allegations. Hence, this order cannot be precluded that the petitioner cannot observe temporary celebration of upcoming Durga Puja and clearing the super at the cost of the plaintiff petitioner without changing the nature and character of the property. Now, kindly come to their, my lord, plaint and the schedule of that plaint, my lord. My lord will find it at.
But what is the reason for rejecting?
My lord, since the survey first commissioner has delayed in conducting the survey, my lord. As such, this is the ground. And second point is taken that a suit filed by the defendants that was pending in the same court. Both the suits there are order of status quo. And in 2024, a similar situation arose. The learned court allowed me to perform the Durga Puja. I have annexed that order. We find it at page 51.
But Mr. Ganguly, only one thing, you can perform the, even if you are allowed to perform the Durga Puja, so their right to of ingress and egress you cannot, that entrance you cannot obstruct.
No, there is an undertaking to that effect. I will not obstruct that.
Undertaking is one thing, and what we will do.
No, every year, that has been done. Kindly see, they have not lodged any complaint or filed any application before the learned court saying that they have, after the puja, they have not. We have
Not after the puja. After the puja, we will remove. There cannot be any obstruction. But during the when you will construct the.
I am leaving this passage.
Where is your application?
At page 151 application, page 29. The dark numbers, in which this defendants are paying, it's altogether different.
So this is the sketch map.
This is the sketch map.
Now this passage, this dotted line,
yes,
that will be the passage.
That will be the passage, and the this boundary wall. There will be the dependent.
Where he will.
Core 3.
Only core.
Yes. Core, yes.
Only core. But entrance will be through that passage, Mr. Ganguly. They will not be allowed to use.
I have the photographs. Kindly see. There is the passage.
From this sketch map, page 31.
This is the passage. Enter passage.
Yes.
I will be.
When crowds will come
to
visit your pandal.
This is a family puja, household puja.
Family puja.
This is not Sarvajanin puja. It's my own puja. Kindly come to that, the other permissions, other year permissions. Kindly see the orders.
All right. Heard Mr. Ganguly, learned advocate for the petition.
My lord, may I mention?
Yes.
My lord, may I mention, my lord?
Next, madam, item
Sir.
was 60, madam.
Yes, yes.
May I mention, my lord? My lord, one matter was fixed at 4 p.m., my lord. That was item number 429, my lord. When can it be taken, my lord?
Yesterday, these motions are of yesterday's motion.
My lord.
So you chose not to appear after 12. And
Lord, kindly
if
fix the
motions
date,
are
my
not
lord.
taken up, you will say motions.
My lord, kindly fix, my lord.
Yes, Mr. Rai.
My lord, kindly fix, my lord.
4 o'clock matter.
Mr. Rai,
Yes,
my
can
lord.
be done now. Can it be taken up after the vacations?
Any day after vacation.
You are hearing that matter.
For me, not after vacation, my lord. My lord.
All right. What is your item number?
424, I think.
424. 424 টা না? 424 টা ওই 424 টা রেখে দিন list this matter. Fourth.
Fine.
Fifth করে দিন। Fourth at 4. 4th of October, 4th of November at 4 p.m. Yes.
My lord, our matter can be fixed at on 19,
Yes, what is your item number?
429, my lord.
429. Who is your other side?
The other side was here, actually.
He has left. 429.
Yes, my lord.
Yes, let it remain. Tomorrow, let me see.
Tomorrow, my lord, at 4.
Let me see. Yes, yes.
Can it be fixed, my lord?
My lord, Mr. Shurojit Nath Mitra was addressing, my lord, this is that property on VIP Road, 40,000 square feet and odd, my lord. Order 30.
What can be done? Maybe difficult this side of
Tomorrow can be 4 p.m., my lord.
maybe difficult because motions
Yes, lordship is giving precedence to motions now because
has to be Mr.
We
Dotto, there are only 5-6 working days left.
my lord, in that case, like Mr. Anirban raised matter, I will take third. He took fourth. My lord kindly gives me third, fourth. My other side is here, my lord. They are here.
Where is he?
My lord is here.
Wait, what is your item number?
430.
430 টা I mean, ask your advocate on record. At 4 p.m. করে দিন। At 4 p.m.
My lord, only one injustice. My lord,
Third and
one.
third of November.
You said 3rd of November.
Because otherwise, my lord, motions every day, my lord, it will happen the same way.
Difficult now, eh? Oh, 3rd of April monthly list is there. November is monthly list.
এখন ধরে নিন আমরা রেডি আছি তো
3rd of November is monthly
My lord,
list.
fifth, in that case.
5th is holiday.
My lord, first week also I am. My lord, any day first week, my lord, gives me.
6th.
এই সেকেন্ড টু 4 পিএম রাখবে
6th.
My lord, one.
429
One.
429
Now I have
রাখো না
rang the learned advocate.
রাখো না সেকেন্ড
for
4
finding
পিএম
that-
সেকেন্ড 4 পিএম
Now he says, my lord, he has given no objection. He says that he
429
has
যেটা
given no
সেকেন্ড 4 পিএম
কবে করছিস?
Then Mr. Ganguly, you have to serve.
হ্যাঁ হ্যাঁ হ্যাঁ
But you have to serve then, Mr. Otherwise, it
করবে এখন করবে
My lord, they want to, my lord.
where is the property?
Bardhaman.
Please serve then. Then it will be difficult. Today we are on Tuesday. Can you not serve? I can keep it on Friday.
Yes.
এই যেটা হলো ওই টু উইমেন সেন্টার, হোয়াট ইজ ইউর আইটেম নাম্বার? 59 এর অর্ডার রেকর্ড করে দিন। ওই প্রথমে কি বলেছেন বলুন মিস্টার Do it before Wednesday. One day he has also to engage. I think it's better on Monday. You have difficulty. All right, Friday thakuk tapan. Friday under the heading to be mentioned.
Lot 429, lot 429, it is the second. Tell you, Lordship, we are really, my daughter, she has not qualified to be appointed not in New York University in one of the courses. Now for that, she has to qualify clear courses, not one is not that advanced examination and second is not scholastic assessment exam. Now scholastic assessment exam is the exam by which she can enhance her grade by the
What
time
do you
she-
want, Mr.
Lord-
Chakraborty?
this is for maintenance. 1 lakh impugned order, 1 lakh from the date of order. And I have shown that he earns 15 lakhs a month, one course 70. Mr. Mukherjee, I can do it now. My lord is very tired. I understand. Lord, my daughter's, she has to get herself admitted in Milord scholastic assessment test. Some of the institutes they conduct, which travels in private jet, getting some amount so that I can get her admitted.
Mr. Mukherjee, can you not consider for your daughter?
But only thing, I don't know whether nowadays parallel proceedings can be continued because in the court below, same prayer, same petition has been filed that has been pending for consideration.
He says
With
it.
that, this
He
juncture,
say,
whether
he
you
say,
not
he say, tell the truth. He say, look, this is the problem.
if
That's in
he-
TV.
if he tells
That's in
if he
TV.
tells the-
Why don't you say that?
tells the
This is misleading.
only one paragraph.
This is misleading. What you are saying.
1 minute.
One
No,
minute,
no,
one
no,
minute.
no, 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 misleading, no,
Parallel.
no, no, this
Mr.
misleading.
Mukherjee, I will, if you say no,
Bolo, bolo, bolo.
Mr. Mukherjee, I will hear that. I mean, I'm only asking you, can you not consider for the daughter's
Yes,
education?
from the date of
That is
filing.
what I am saying.
Yes.
But misleading kindly pass,
No,
no.
misleading.
No, I stand by what I said.
I'm not on
I
the.
stand by what I said. I don't care about
Mr.
what
Mr.
is.
Mukherjee, I'm not.
What
on
is
this.
correct is correct.
I'm not on that.
If he stand that, no.
What is
There-
correct is correct.
Mr.
There must be
Chakraborty,
something.
don't use those
Sir,
languages.
kindly think about it.
Yes.
Can you
Thank you.
consider for the
No,
daughters?
if the situation is otherwise, I will not. Kindly think about it.
Well, court is not an interactive marching milord, court will pass order. So kindly give us a act. Kindly give us any date, milord, any time when my lord will give me 15 minutes time.
Sir Chakraborty, you know,
It is appear tomorrow as the first 4 p.m. matter. Let it tomorrow as the first.
let it appear because Mr. Chakraborty, some of the 4 PMs have been adjourned.
Lord, it was the first 4 p.m. at a day before yesterday on Monday. Monday there was no court.
Hey,
Today
sir, which
it has become second, 429.
So some has been adjourned today. Might be a first today.
Kindly direct that. No, tomorrow let it the first Monday so that I get 15 minutes audience.
ছিলাম আমার 404
কোনো
নাম্বার ছিল
application file করো না,
আমার
তোমার
ওটা ইয়েতে
এই
মোটাই
যে করো না।
মেইনটেনেবিলিটি এর
হ্যাঁ?
কোশ্চেন ছিল
Please
ওটা যদি
করতে
আপনি
করতে।
শুনতেন কালকে
কালকে 4 p.m. কটা
অনেক
আছে?
দূরে আছে
কালকে 4 p.m. কটা আছে?
কালকে একটু যদি কাইন্ডলি শুনতেন
আমাদেরটা বোধহয় 6-11 ডেট।